Thank you very much. And let me start by saying how honored I am to stand here at this 40th anniversary of SMER and talk to you about this important topic. So, protection of human rights in biomedicine, as Caesar just said, human rights focus on the individuals, and we also must not forget the public, the larger groups of society. But I start with human rights. And the 21st century has without doubt brought us tremendous new possibilities in the field of biomedicine, but they come with huge challenges and partly unknown risks to individuals as well as the public and society. So handling these challenges and risks involve difficult ethical issues, but is also a matter of democracy and access to justice. Who decides what our future world should look like, what risks to accept, and who should have access to the benefits gained? In the field of biomedicine, many fundamental rights may be at stake. For example, the right to protection of life, health, and personal freedom, but also individual self-determination, physical and informational privacy, non-discrimination, and access to effective legal remedies. So, if rights cannot be enforced, they are hard to fully implement. Is this important? Do we care? Well, a study from the National Human Rights Institutions of Denmark, Norway, and Sweden shows that while a strong majority of over 80% of the respondents think that human rights are important, many of them believe that human rights abuses occur in Scandinavia. Across all three countries, the top 5 rights perceived to be most at risk include the right to a healthy environment, the right to health, and freedom from discrimination. So when society is faced with emerging new phenomena or technologies, not least in the area of biomedicine and research, issues of regulation sooner or later emerge. Some policymakers and stakeholders will call for protective legislation, restricting the area of lawful activities and providing public control, whereas others will advocate extensive freedom, often in the interest of scientific and economic development. The overall picture is rarely simple, since conflicting and coinciding private and public interests form an irregular and complex pattern, as we have seen, for example, during the COVID pandemic, but also more generally in biomedical research, genetics, the use of human tissue and data. As we strive to govern the rapidly developing field of biomedicine in order for it to benefit humanity and promote the realization of fundamental human rights, we need to reflect on the various forms of governance and types of normative systems available to achieve this goal, as well as the roles of different actors involved at various levels of society. One of the more important functions of legal norms is precisely to provide a just means for the balancing and protection of important interests in society. But when the need for new legal regulation is considered, the process must also include the assessment of alternative solutions, as well as the applicability of already existing legislation, in order to establish what is already covered at various regulatory levels and what is actually unregulated or inappropriately regulated. This discussion is well known from the area of genetics, where the justification of so-called genetic exceptionalism was thoroughly debated the past decades. It may, however, of course, be argued that not all areas of biomedicine are suited to legal regulation. One reason often brought forward is the need for flexibility in areas of rapidly developing science and technology. Other steering modes could be used to influence the behavior of the public and various parties concerned. For example, information and public debate aimed at raising the level of knowledge and general awareness in a certain field, thus paving the way for responsible choices and self-imposed restrictions. Also in the form of self-regulation. So there may thus be situations where other alternatives are found more appropriate or more effective than legal regulation. One distinction often made is the one between formally binding hard law regulation and various types of so-called soft law in the form of codes of conduct, declarations, recommendations, guidelines, policy documents, etc. So even though soft law regulation is normally classified as rules that are not legally binding as such, the boundary between hard law and soft law is not distinct, and the two types of regulation often interact in different ways. Sometimes soft law can be viewed as a transitional mode of regulation, a precursor to binding legal instruments, but it may also be used as a complementing or as an independent alternative steering mode, conveying power to actors with only limited influence in traditional regulatory processes. Soft law is thus a tool available also to NGOs, as well as other actors with limited regulatory power, such as the OECD. It is also considered to leave more room for flexibility and rapid reactions, and is believed to be particularly useful when dealing with complex and diverse problems that are characterized by uncertainty. So this type of regulation is therefore often used in areas of human rights, biotechnology, and the environment. The status of a soft law document will be dependent on context as well as time. Guidelines issued, for example, by a ministry or by a competent public authority are likely to have a formally stronger standing than a code of conduct issued by a professional organization. However, in the field of biomedicine, professional ethics has by tradition enjoyed a particularly strong standing, and the professions may sometimes even consider it more legitimate than laws made in Parliament. It is obvious that questions may well be raised concerning the democratic legitimacy of some soft law. And additionally, since soft law in itself does not provide any legal sanctions, such regulation alone would often seem insufficient where important interests must be guaranteed strong and robust protection, such as, for instance, human rights. So, ethics or law? Well, let's make it simple and do as everyone else. We go to Google AI. Ethics provides the philosophical foundation and moral justification for human rights, while human rights law transforms these ethical claims into enforceable legal standards and duties. So law and ethics thus have complementing and interacting roles, where law provides a legal framework and binding obligations for governments to protect and promote the fundamental freedoms and human rights of individuals and groups, while human rights ethics focuses on the moral and philosophical principles that underpin these rights, such as dignity, justice, and the inherent worth of all people. As already mentioned, regulation could be introduced at different levels of society. Some issues are of such global interest that they warrant regulation in public international law, and some fall within the remit of supranational organizations such as the European Unions, whereas others are considered to be primarily a question of national policy and regulation, or even local regulation. The appropriate level of the regulation is a question of legal competency, but also of suitability and principles of subsidiarity. To a certain extent, the level at which different norms can be found may also illustrate the perceived importance and universality of the interests they are aimed at protecting, for example, in the area of human rights or environment. However, in some areas of society, pluralism of cultural and religious values, as well as legal traditions, not just because of misinformation, can make it difficult to reach international or even regional consensus. Also, highly important issues may thus be subject to binding regulation only at the domestic level, or may even be left unregulated. And when norms and standards vary, incentives for medical tourism arise. It is understandable that the development of legally binding international or regional rules can be very challenging to achieve when it comes to reaching consensus on matters influenced by pluralism of values and norms. Various soft law regulations may then play a more important role in filling the voids, but even with regard to non-binding statements, consensus can sometimes prove impossible to reach. As for example, with the 2005 UN Declaration on Human Cloning, after 191 nations, 84 voted in favor of a non-binding statement to ban cloning, but 34 voted against and 37 abstained. And among those voting against were Sweden, France, the UK. Despite these difficulties, we have seen an increase in legal regulation in the field of biomedicine these past decades, not only relating to new technology. At the European level, we have two particularly important actors when it comes to the regulation of biomedicine: the Council of Europe and the European Union. While the Council of Europe is considered the most important and influential body with regard to the protection of human rights, the EU, with its supranational character and primary focus on economical cooperation and development, is in many ways a more powerful institution, despite the fact that the EU only has limited regulatory powers in areas of healthcare, research ethics, and human rights. Important spillover effects and more general regulatory frameworks related to, for example, product safety or the free movement of people and services have had a huge impact in the field of biomedicine. However, during these past 40 years, the most important international achievement in the transition towards stronger legal protection of human rights in biomedicine must, of course, be the adoption of the 1997 Council of Europe Convention on Human Rights in Biomedicine. During the drafting period, it was originally called the Bioethics Convention, but this title was found to be misleading since the convention was not a collection of ethical norms, but a legal framework, and the difference between actual legislation and ethical norms could not be invalidated. The fact that several European countries did not sign, for instance, Belgium, Germany, Ireland, and the UK, and that some signatories to this day, almost 30 years later, have not ratified the convention, does not change the tremendous impact of this convention and its additional protocols. Those who have chosen not to accede the convention would seem to have done so for a number of different reasons, partly connected to the challenges of varying societal, cultural, and religious values. Even so, the impact of the convention is obvious also in these countries. In Sweden, where the ambition has always been to ratify, we see the influence of the convention and relevant protocols in, for example, Swedish legislation on biobanking, ethics review on research, genetic integrity, our Patients Act, and the still ongoing discussion on the rights of incapacitated adults in healthcare and research. It is clear that many issues in biomedicine call for international collaboration, at the same time as national conditions, diversity of religious and cultural values, history, legal traditions may cause obstacles to consensus. At the global level, regulation of biomedicine can thus still be found only in soft law documents, such as, for example, the UNESCO Declaration on Bioethics and Human Rights. When looking to the future, additional worrying facts are, of course, that our institutions and systems for the protection of human rights are increasingly being questioned at the same time as the number of democracies decreases. It could definitely be argued that we are witnessing an increasing disregard for the rule of law and human rights in practice, as has already been pointed out this morning. In any regulatory project, a primary task is to establish the overall aims and objectives. What is the perceived need for new or revised regulation in this particular area, based on our knowledge of new or expected developments? This first stage is, of course, where ethics councils, advisory groups, and multidisciplinary task forces are of vital importance as lookouts towards developments in science and society, promoting public awareness and debate, and providing comprehensive information and well-balanced advice to decision makers at various levels. This stage is about identifying the different interests at stake and the degree of protection that is needed and justified, and then deciding on the required scope of the regulation, what norms to apply based on a careful balancing of the interests concerned. This is often a task for philosophers, ethicists, and experts in political science, but also for lawyers when it comes to requirements of respect for human rights and other fundamental legal principles, such as proportionality and legal predictability. At the domestic level of Sweden, SMER has now filled this important function for 40 years in a brilliant way. This is the same period as the Council of Europe has had their Bioethics Committee, now the Steering Committee for Human Rights in the field of biomedicine. And as we have already heard, in 1991, the EU Commission introduced their European Group of Ethics, and during these past 40 years, many countries have introduced similar functions within the European Union, forming the NEC Forum. In our rapidly changing and increasingly globalized world, we are in great need of sharing experiences, new information, analysis, and tentative solutions across as well as within borders. Among the challenges now facing us, there are certainly new ones, not least in the area of AI, where EU regulation with binding legal rules of a general character was recently adopted, while ongoing work to promote ethical standards, guidelines, and regulations specifically focused on the use of AI in healthcare is taking place, for instance, in the World Health Organization, the Council of Europe, and national ethics councils such as SMER provide an important basis for the domestic discussion and public debate. As also already mentioned, many of the challenges are not really new. Some were just never properly solved. For instance, in Sweden, timely and equal access to healthcare or protection of the rights of incapacitated adults. Some are eternal. Others reappear in new light as new technologies evolve. As we look forward, we must also look back. What is human? Well, what did we learn in the context of human-animal hybrids and chimeras that might apply in the context of cyborgs? And with designer babies discussed for decades, how will our perception of human value be affected, and what other risks may there be to future generations? The national ethics committees must look across disciplines and borders, draw on shared experiences, information, and act as a bridge to domestic decision makers. They provide ethical principles and analyses as foundation and justification, which can, when their governments and parliaments so choose, be transformed into legal standards and duties, realizing enforceable human rights. For all this work, I say thank you, SMER, and congratulations on these past 40 years of invaluable contributions, and the best wishes for the interesting and challenging times to come. Thank you.